I was talking with a client last week, and they had gotten a previous divorce before the law changed as far as what you are served with as a defendant, and it also applies to you as a plaintiff in a divorce under today's statutes laws. And that is that now we are required not only to go and give a summons with notice or a summons with a complaint to go and start the action to the defendant, but there are three other documents as well. One is a QDRO, and that is a QDRO notice, I should say, and that is telling you that you are not going to be able as a defendant or plaintiff to be on the other party's health insurance after the divorce. So you've got QDRO rights, okay, which means that you can go and get insurance, which will be very expensive, from that company normally for 6 months. Usually that is cost prohibitive. Another thing is an injunction. Essentially, this is an injunction notice so that no assets of the divorce can be transferred. And that's very important, so that everything stays status quo until the judge reviews it and makes sure that everything is divided the way that it should be divided. The last thing is that you get notification that maintenance is now codified. What I mean by that is that the law is now that there are specific calculations as far as how the maintenance is determined. We literally go and pop in the numbers as far as your income into the calculator that we have on the internet, and it tells us exactly how much that maintenance is. But the legislature and the governor felt it was important that that notice is given when you are served with papers.